So, good afternoon to all of you. Good afternoon to all of you. On the behalf of ISC, IMD College of Law, we have just started the series of event. So, today we will start a new webinar on the IPR challenge and opportunities. So today we have our esteemed guest, Ms. Varni Krishnan. She has done LLB from the Lloyd College in 2017. Afterward, she has enrolled, completed the Master in Law from Amity University, Noida. And she is the co-founder of Pan Altruist Education Care. More than 10 books under traded, ISBN number and the publication. So it is a challenging topic, IPR challenge. So now I will give mic to the our learned guest for this IPR challenge opportunity. This webinar is going to be open it. Okay, madam, mic to given to you.
Thank you, sir. So good afternoon, one and all present here. Firstly, I would take this opportunity to thank everyone and especially IMT College for having me here, for having this discussion based on IPR opportunities and challenges. So firstly, I'll actually usually webinars are it can be quite boring, right? So webinars, what usually happens is when we have a webinar, there is a person who is speaking and the person will be speaking with a lot of contents and sometimes we tend to miss on those contents, right? So I don't want to just speak on a one-way basis where we are just covering as to what IPR is, as to what intellectual property right is, because to be very honest, that's a very boring topic. And I'm sure as students, you will all be anyways be studying what is IPR, what is a trademark, what is a patent, what is a copyright, etc. So let's leave all those things. Let's keep them aside. Okay, so I'll just start with a basic storyline of how I got into the field of IPR and how I deal with copyrights so that it gives an idea. Because today's topic, whatever we have with us, is a very challenging topic, as said by the sir, because it's actually something IPR एक ऐसा concept है हमारे country में which is not touched, which is not exploited by lawyers, मतलब people who are in the field of law, even people who are in the field of artistry or academics, right? तो होता क्या है, like even when I was a student, I used to hate IPR, and I'm being very open. I used to hate the concept of IPR. Why? Because IPR, intellectual property rights, where usually it's not something that our Indian law had from its, like let's say from a very big historical point. Like अभी हम कहते हैं CPC, Civil Procedure Code, या फिर Criminal Procedure Code. So the difference that IPR and CPC, CRPC जैसे law में difference ये है, फॉर एग्जाम्पल CPC, CRPC, ये सब कुछ ऐसे कोड्स हैं जो हमारे इंडियन लॉ में बहुत पहले से एग्जिस्ट करता है. It's not like we have not had this, because even when the time of the British era, we had so much of civil cases going on, criminal cases going on. We used to have jury trial, then our Supreme Court, then presidency towns में courts आया, and all these courts used to deal about majorly about the civil cases, public administration cases या फिर criminal cases. करेक्ट. बट IPR एक ऐसा टॉपिक था जो कभी हमारे हिस्टोरिकल पॉइंट ऑफ व्यू से टच ही नहीं हुआ. एंड द रीजन बीइंग इंडिया वाज अ कॉलोनियल स्टेट. करेक्ट. सो कॉलोनियल स्टेट में क्या होता था, द रूलर्स, आई एम रेफरिंग टू ब्रिटिश पीपल हियर, they used to come, they used to be the owner of the companies, they used to be the owner of the laws, and they used to take everything from us. Correct. सो एवरीथिंग से व्हाट आई मीन इज बिजनेसेस, क्योंकि हमारे पास बिजनेस स्टार्ट करने का कोई स्कोप ही नहीं था उस टाइम पे. तो ऑब्वियसली वी वुडंट हैव एनी लॉ फॉर इट, राइट? ओनली इफ वी हैव सम लॉ, देन ओनली वील हैव प्रोटेक्शन आल्सो. So we didn't have any protection against such rights because those rights were never considered to be rights, right? I can see hands going up. May I know why?
Madam, they want to ask some doubts. Let's you complete your presentation. Afterwards, we will take the question one by one.
Sure. Yeah, so I'll continue. So we never had those rights which we nowadays call as IPR, correct? So ये जो IPR का concept है, ये IPR का concept majorly हमारे independence के बाद आया, correct? And it's not like immediately after independence we got the concept of IPR. Firstly, we were building our nation, we were developing, we were making 5-year plans, we were working on it. And even then, there were some governments which never recognized IPR because obviously we didn't have the development to it. करेक्ट आईपीआर बेसिकली ही एक ऐसा राइट है या फिर एक ऐसा चीज है जो विच इज गिवन ऑन डेवलपमेंट बेसिस, right? And that development itself started after a very later period after independence, to be honest. And then what happened is, and how this development came up. So this development came up because we had some international laws going on around our world. United Nations came into play in 1945. And once United Nations was set up, slowly and gradually, more and more countries were growing into globalization. Slowly, they were moving into globalization. People were recognizing what companies are, what books are, what artistry works are, right? What music is, what is original concept. All those things were starting to come into play. Okay. So what happened is the first thing that we had with us was in the year 1970, and that was Patents Act. So Patents Act first आने का reason क्या था? Because we were a very scientific country from the very beginning. So scientific countries, what I mean is India has always produced great scientists around the world, right? We have so many researchers, we have so many great people who are legends, like APJ Abdul Kalam, who have done so many, like they have invented so many things. तो हमारा जो कंट्री था हमेशा से वी वेर वेरी बेस्ड ऑन इन्वेंशंस. वी ऑलवेज हैड दैट क्रिएटिव माइंड. बस हमारे पास डेवलपमेंट स्ट्रेटेजीज नहीं थी या फिर फाइनेंस नहीं था. बट अदर देन दैट, इफ वी टॉक अबाउट द इन्वेंशंस, वी वेर एट अ ग्रेट प्लेस. तो इसीलिए इट वाज द फर्स्ट रिजल्ट दैट द पेटेंट्स एक्ट वाज drafted in 1970 and it came into action. Okay, but then that patent act was very strict. Okay, the Patent Act was very strict. So Patent Act strict होने से what I mean is there were so many developments. Like जब 1970 में आया तब तो it was very basic and उस टाइम पे किसी को उसकी कोई value नहीं थी and we were just moving on. Correct? But slowly 1991 में when we had the globalization and when new economic policy came into play, things started to change. Correct? Because more and more companies were coming to India. Our Indian companies were going to foreign lands and they were opening their branch. So us time pe the government had a striking point as to what can be the safety, right? Abhi aap ek different state mein jaake apna company kholte hain. So what is the safety that you have? What are the rights that you are going to get? What is the tax that you are going to pay? Or what are the tax benefits that you are going to get? Correct? So there are those things started to come into action, and that's how we started to realize as a government that we are lacking behind in intellectual property rights. And after 1991, slowly we started developing acts. We started to collaborate with international bodies like WIPO, World Intellectual Property Organization. We collaborated with them, and then came Trademarks Act. Right after 1994, the Trademarks Act came. So that was the reason. So the point that we are discussing here is, ये जो सारे year हैं, ये जो सारे act हैं, definitely you can find this better in your books. There's no doubt. But the main object of this webinar is the first thing that we have to discuss what are the opportunities that lies ahead us and what are the challenges in pursuing those opportunities. Correct? So we'll deal about those practical aspects that surround these opportunities and the challenges. Okay, so moving on, books एक ऐसा चीज था, like you all might know better than me maybe, books के लिए हम copyright use करते हैं. Correct? तो copyright एक ऐसा चीज है. Firstly, trade जो हमारा IPR है, basically in India we have 4 type of IPRs. There might be subcategories to it, but then 4 are the main categories. So the first one is patent, second one is trademark, next is the copyright, and fourth is the design, industrial design. And it can have many other things like geographical indication and all those. We can say like that, but that's the fourth one. Okay. So patents, though we all know that patents are mainly for inventions or a new product or a process. Uske liye hota hai patent. Correct? Moving on, trademark. Trademark, usually trademark bolte hi we should have a ringing in our brain that it connects businesses. Okay, so whenever you are talking about a business or whenever you are talking about a new company, trademark will come into play because trademark is something through which a company is identified. Okay. Thirdly, we have copyright. So copyright is basically where we deal for people or like who are artists, who are singers, who are music directors, lyricists, directors, authors, all those people come under copyright. And then lastly, designs. So designs can be industrial designs, it can be a geographical indication, and all those things comes under the design portion. And the design portion is little complicated because it is usually dealt by major companies who have a designing authority within our country, and they are majorly governing it. Okay. So coming back to the point, after globalization, when companies started to raise, we started to have these laws or the requirement to have these laws. And as and when we started to move ahead, there were questions that came like to the government and to the legislative authority dealing and enacting these acts. So what these questions were, for instance, let's say हम बोलते हैं patent is just for a new product or a process. Okay, so पहला सवाल जो आया like as in एक interesting सवाल जो आया सबके माइंड में, food हम सबको पता है, खाना is a very common thing, right? हम सब खाना बनाते हैं, मम्मी बनाती है, हम खाते हैं, we go to restaurants and eat, we eat different type of cuisines, Asian, American, Mexican, there are so many things, right? So the first question that came to mind was, can food come under patent? Correct? तो उस टाइम पे जो हमारा लॉ था, लाइक वी वर डिस्कसिंग द 1970 एक्ट, इट नेवर इंक्लूडेड फूड. ओके, इट ऑलवेज इंक्लूडेड प्रोसेस या प्रोसीजर. मतलब ही हम यही सोचते हैं कि हम एक लैब में खड़े हैं एंड वी आर डूइंग द साइंटिफिक प्रोसेस एंड देन वी आर फाइंडिंग अ प्रोडक्ट और इन्वेंटिंग समथिंग एंड उसका पेटेंट हम लेते हैं. दैट वाज द मेजर बैकड्रॉप ऑफ दैट पेटेंट एक्ट. ओके, बेसिक छोटी छोटी चीजों को हमने छोड़ दिया. वी जस्ट केप्ट इन माइंड द बिगर थिंग्स and that's when the problem started. So slowly, I don't know how many of you have heard about Tirupati Balaji temple, which is in Andhra Pradesh. So there is a laddu made there, and that laddu is a patented item, and that patent was given only after 2005. Why? Because पहले there were many deliberations on why to give and why not to give patent to the laddu. Why? Because laddu तो हर जगह बनता है. लड्डू तो हम घर पे भी बनाते हैं. लड्डू हम हल्दीराम्स में जाते हैं तो हल्दीराम्स में भी मिल जाता है. We get laddu in all the हलवाई shops. And ऊपर से इंडिया इतना कल्चरल सेटअप वाला कंट्री है. We have laddus in all the states. Like साउथ का लड्डू अलग होता है, नॉर्थ का लड्डू अलग होता है. But then why Tirupati's laddu was the question. Because then the research started. Then we started to include all the pointers, right? And then slowly we went into the concept that the procedure or the process to make the laddu may not be same. शायद हो सकता है जो आउटकम बाहर आए, that outcome might be same. Like लड्डू हर जगह पे शायद एक येलोइश कलर में होता है और गोल में होता है. We can say that, but we can't say that the process is same throughout, right? The process of making. That's how this point came into place. And after 2005, we started recognizing patents or we started giving out patents for food. And currently, if you see, the main challenge is that the actually challenges surrounding patents, copyrights, trademarks, or IPR at its large is that people do not have the awareness as to what or how to pursue IPR. That is the first major thing. So if I come back to my area of expertise, I have been an academician. From the time I have passed out, from the time I have started my company deals with academics. So basically academic means books. So we publish books. But what I always observe is people do not have an idea of how important writing a book or how important the preserving of the contents can be. Right? अभी for example हम स्कूल से पढ़ते हुए आते हैं कि कॉपी मत करो, आगे पीछे दूसरों का देख के कॉपी मत करो. That small instance is actually very important in life. When you see the IPR aspects of it, it's very important. Because as and when, let's say you are an artistic person, you are writing a book, you are an author, or you are maybe writing contents or you're drafting contents, what happens is that single thing of copying a single line from another person's book can be called plagiarism, and that plagiarism can be very, very, severe, because ho sakta hai ki you might be fined for that, you might be put in jail for that, because that's what copyright is. Correct? So let's say if I have written a book and I have a copyright, I have taken a copyright from the government and I have the copyright, and somebody is using my own lines or some phrases from my books, or even making some reference to an example that I have taken, that will amount to my copyright being infringed. And that is a punishable offense. Okay. But the thing is, in our country, the major challenge is that many people avoid IPR because the scope of IPR, we think that it is less. But deep down, the scope of IPR is quite more. Because what happens is, right now, if we see, even if you take out MCA website, you can just take a look. Just any day you're free, just go to MCA website and look at the companies that are being formed, that are being registered on a day-to-day basis. If you see that there are so many companies which get registered in a day, and all these companies somehow have a trademark, have a logo, they might have some representation, they might have a name, that name should be unique. So all this comes under trademark, correct? And there are so many companies which are growing day by day. It's just that big companies stopped, do not notice these things, or these most of the things goes unnoticed. Only bigger companies notice. And why? Because only if, let's say, there is a company which is formed और उस कंपनी का इनकम ज्यादा नहीं है, तो पैसे भी वो नोटिस में क्यों आएगा, right? So even if that company is stealing contents or stealing the trademark or stealing the logo from other people's company, it's not going to get noticed till the time that company develops, right? So this aspect is the biggest challenge that our country is facing, that we don't have the exact knowledge, or we don't have the exact, let's say, mechanism to check for IPR, fight for IPR, and keep our rights to ourselves. That is a huge issue. Okay, so what happens is, abhi for example, I'll give you an example in terms of copyright also. शायद आप सब लोगों ने 3 Idiots movie देखी होगी आमिर खान की. So what happened is that movie is actually based on a book written by Chetan Bhagat. So Chetan Bhagat is a very good author. Okay, so he has written a lot of books, and उस book का नाम था 5 Point Someone, and based on 5 Point Someone was the movie taken. शायद ये हम सबको पता है, right? So what happened is, जब वो मूवी बन रही थी, तो प्रोड्यूसर थे विधु विनोद चोपड़ा. तो he came and made a pact with चेतन भगत saying that आपके किताब के कुछ जो कंटेंट्स होंगे we'll be using in our movie, correct? And उसके लिए he was going to pay a huge amount of money to चेतन भगत. He said that I'll be taking your contents, I'll be using the story, and उस basis पे ये मूवी बनेगा, and उसके लिए I'll be paying you this. Also, जब वो मूवी थिएटर पे प्ले होगा या किसी भी ऐप या किसी भी OTT में प्ले होगा, there would be credits. You can see the credits. Credits means what? Credits means नीचे लिखा होगा taken from the book 5 Point Someone by Chetan Bhagat. This is the credit line. So that credit would be given. So what happened is, everyone was happy, the movie was made, and जब movie का release time था, so usually what happens is the actors and the directors go on for a interview, and all those things keeps happening, right? So when all these things were happening, in one of the interview, the director, the actor, casually, they just said that not all part of the movie is based on the book. बुक सिर्फ है, बट वो बुक से सिर्फ 5% बेस्ड है, बाकी हमारी खुद की क्रिएटिविटी है, इज व्हाट द डायरेक्टर एंड द एक्टर सेड इन एन इंटरव्यू. एंड दिस क्रिएटेड अ ह्यूज इशू. This became a very, very huge issue. Why? Because Chetan Bhagat immediately filed a petition. It's not for money, right? Money तो उनको वैसे भी मिला, money तो उनको contract basis पे वैसे भी मिला, तो it's not for money, but it's for the credit portion. And उसके जो रिजल्ट था, उसका रिजल्ट ये था that the director and the producer had to pay a huge sum because of that, and then include his name, like Chetan Bhagat's name, in all the interviews that they were going, in all the areas that they were talking about, and even then the credit line was increased in the movie. So this all happened only because of a complaint raised by Chetan Bhagat, right? But then what was the benefit that Chetan Bhagat had is, Chetan Bhagat is a very renowned author. He's very famous throughout the world. His books are what, best-selling books. He would have written 9 to 10 books, and all the books are best-selling. But then what about the small writers? What about the small authors? Like small authors who are just growing or budding, let's say. they don't have any rights because पता भी नहीं चलता होगा कि उनका contents किसने उठा लिया, किसने डाल दिया. We never know, right? Why? Because our laws are not that strict. Our laws are not that strict where one person can go and complain. Let's say I'm writing a book. I'm not famous. I'm writing a book. Somebody has stolen 2 or 3 lines from my book. Even if I know, I can't do anything. Why? Because I know if I go and file a complaint in the copyright office, I'll place a complaint stating that I have taken the copyright number and this person has stolen contents from my book. But the mechanism to reach out to justice is too long. Correct? I would have to prove everything. And the वो proof का जो first step है, वो step क्या है पता है? It is the registration of copyright number. So IPR में problem ही यही है कि whatever IPR you may choose patent, you choose trademark, you choose copyright, you choose industrial license or whatever that might be, geographical indication, सब में registration करना is mandatory. If you are not registering yourself, then there is no way that you can fight a case or you can file a complaint or you can even claim damages. That is the biggest part. And that registration, जो registration हमारे IPR में हमारे country में होता है, that checks are actually very poor. I'll say this very openly because that's the truth. What happens is if you're going for a copyright, you're going to get a copyright, the procedure that you have to undergo is way too long because you will have to go, you will have to follow a lot of steps, you will have to give a lot of instructions, you will have to give a lot of documents, and firstly when you go you have to prove that the content is yours, जो कि बहुत मुश्किल है. मतलब आपने एक बुक लिखा, आपसे मैं बोल रहा हूँ prove करो, how will you prove that? Correct? So these are the difficulties that comes in our country for everything, and especially for patent. Patent is it's actually a very important thing and it's very difficult to get because patents are usually given for 20 years. We all know that. So to get a patent, let's say you have invented something, the patent that you will get is not going to come easy. You will have to fight through a lot of steps. You will have to take a lot of measures, and then only you can reach the level of patent to get a patent, right? But when we talk about opportunities, there are a lot of opportunities that are coming. I'll tell you an example of how we can connect to opportunities. Let's take the example of country USA. Okay. So what happens is usually whenever we talk about our law in India, we always compare ourselves with either UK or US. Correct? आपने भी बहुत सारे सब्जेक्ट्स पढ़े होंगे, सब में हम यही पढ़ते हैं कि यूएस में क्या है, यूके में क्या है. द सेम गोज फॉर आईपीआर. तो आईपीआर में हम देखते हैं कि यूएस का क्या है. यूएस उनका सिस्टम बहुत बेसिक है. द कॉन्सेप्ट ऑफ आईपीआर इज प्राइवेट फॉर देम. सो व्हाट डू आई मीन बाय सेइंग प्राइवेट? प्राइवेट मीन्स हमारे कंट्री में सारी चीज के लिए गवर्निंग बॉडी है, गवर्निंग एक्ट है जो लेजिस्लेशन से आता है. अभी पेटेंट है तो मुझे पता है पेटेंट्स एक्ट 2005 देखना पड़ेगा एंड आई हैव टू गो टू द पेटेंट्स ऑफिस. कॉपीराइट है तो कॉपीराइट 1957 मुझे कॉपीराइट ऑफिस जाना पड़ेगा. द सेम वे यूएसए में देयर इज नो पर्टिकुलर एक्ट, even if there is an act that they call as cooperative societies. So cooperative societies क्या करता है? Cooperative societies are just private bodies. अभी for example, if I'm a writer, I'm going to a corporate and I'm living in USA, मुझे कुछ नहीं करना, मुझे बस cooperative society के पास जाना है जो मेरे एरिया में ऑपरेट करने वाला cooperative society है, and all I have to do is just give my contents to them and say कि मेरे को copyright दिला दो. Okay? And I'll be given a copyright. उसके बाद क्या होगा? इफ आई हैव अ प्रॉब्लम, इफ आई हैव एनीथिंग, वो कोऑपरेटिव सोसाइटी उस चीज को हैंडल करेगा. आई डोंट हैव टू रन बिहाइंड और आई डोंट हैव टू गो एंड चेक कि किसने मेरा कंटेंट उठाया या फिर क्या हुआ क्या नहीं हुआ. ये कुछ भी देखने की जरूरत नहीं है, राइट? क्योंकि वो कोऑपरेटिव सोसाइटी ऑलरेडी हमारे बिहाफ पे वो चीज करेगा. ओके, सो दिस इज हाउ यूएसए वर्क्स. And this has helped many artists, like let's say singers, let's say dancers, let's say lyricists. उन लोगों को बहुत हेल्प हुआ है इस चीज से, because all they have to do is get registered with cooperative societies and just see as to okay, एक बार वो registration process complete हो गया, then the measures comes very easy to them. Even if there is an infringement, the cooperative society will take it ahead. So in India, when we talk about the differences, यहाँ पे artist भी आप खुद हो. आर्टिस्ट होने के बाद जो आपने कंटेंट लिखा है उसको प्रिजर्व भी आपको ही करना है, उसके लिए एप्लीकेशन भी आपको ही फाइल करना है. वंस दैट एप्लीकेशन इज डन, द प्रोटेक्शन आल्सो यू हैव टू सी. that is the biggest challenge that we are facing in our country, that there is no governing body. Like we have the legislation, हमारा जो legislation है, it's better than US का legislation. If you look at our act and everything, whatever provisions that we have with us, those provisions are actually better than what USA has. But then the problem is USA जैसा mechanism नहीं है हमारे पास जहां पे we can easily go and easily get our rights from getting infringed. That is the lacuna that we are facing in our country. And that lacuna basically comes from what? The first point that I would suggest is lack of interest. What happens is usually, and this problem even I have faced in my life. So what happens is when we are looking or studying IPR, हम उसको बिल्कुल एक theoretical aspect से देखने लग जाते हैं. And theoretical aspects में अगर आप IPR को देखोगे, it is the most boring subject you can ever study. Why? Because उसमें कुछ नहीं है, इंटरनेशनल लॉ के साथ हमेशा कंपैरिजन करना पड़ता है. There is no history attached to it. There is no storyline attached to it. We have to learn different sections of क्या होता है क्या नहीं होता. Then we have to remember. But then we tend to forget the practical aspects of it. So whenever there is IPR, students usually get away from it. So what happens when we become lawyers or when we get into the field of law, we tend to move away from IPR and get into other things like which are already established, like CPC, CRPC, all those things. We get into those things, IPC, right? Criminal, civil. Us branch mein we are tending more to go into that. But now the trend has changed a little bit because corporate law is coming into play. Companies Act is changing. It's getting amended day by day. There are various tax aspects that we have to look. Correct. So companies जैसे जैसे बढ़ रहा है, then there are more opportunities for IPR because there are more things coming up. But then there is the second point. Like I said, the first point is lack of interest. Second point is lack of measures by companies. What is happening? The second problem is the companies tend to miss out on certain things. Like जब एक company बन रहा होता है, usually we take care of many things. Like किस area में ये operate करेगा, कितने employees होंगे, कितनी salary होगी, कितना क्या होगा, profit कैसे होगा, loss. But then we sometimes miss out on the IPR things. We miss out on one major thing जो हमारा अपना right है, जो हमें preserve करना चाहिए. Those things are missed by the companies. And the result is what? अभी अगर companies were very strict about that, lawyers would have had a chance to get into companies and work for them as IPR lawyers. But then since many companies are losing out on those things, the opportunities are becoming less. Right? So when a company is starting, they are not looking into how to protect their IPR. They are just making a trademark, they are registering it, they are registering their name and starting. That's it. They don't bother about having a law, or they don't bother about having the MOA or AOA updated about what can be done to protect these rights. So that is one of the second biggest challenge that we are facing, that the companies are not willing, or the companies, jitne companies start ho rahe hain, they may not be, they are willing to take up all the work, but then they are not willing to take up the protection measures that needs to be taken. So that is the second challenge that we are facing in terms of trademarks. And when it comes to patents के लिए, the main challenge that we have in our country is the complexity. In terms of understanding two things. So first thing is meaning. पहले तो हम लोगों को यही नहीं पता होगा कि invention क्या है. Like how, what things should be considered within invention. So that understanding lacuna, because we are not reading or we are not experimenting things, we don't have a governing body to ask to. So all this is coming because of that problem. And secondly, for the patent, the next problem is the complexity of the steps that you have to take. Let's say you have invented something. It's not that you have invented and you can go and say, I have invented this product. There are so many documentations involved in it. And the documentations has actually complicated a lot of things in our country. If we compare ourselves, if we compare our talent, and if we compare our creativity with other countries, we are far more ahead. That's why most of Indians are getting work in America and London, Europe, everywhere. But then when it comes, and the main reason is because they want people like us. They want people like with brain, with creativity and all those things. But what happens in our own country is, if I'm inventing something, I have no recognition here, right? I'm afraid to go to the governing body and say that, okay, I have made this invention. Why? Because of the complexity. You need money to face all the steps. That is one part. And not everybody is financially sound. And then the complexity of the steps, like if I go and say I've invented something, second thing that they are going to tell me is, ye cheez leke aao, ye document leke aao, this you bring, this you get, and then you prove that this invention is yours. So wo karte, it's like I'll lose my creativity brain itself. I'll lose the interest itself. So that is another complexity which surrounds IPR and particularly patents. Okay, next comes the geographical indication. So what happens with geographical indication is, as the name suggests, you would all know that geographical indication relates to some places, like particularly geographical area. Let's say very brief example, हम लोग market जाते हैं, हमें कश्मीर apple दिखता है, तो that Kashmiri apple जो हम कहते हैं, that is a geographical indication. Why? Because that apple comes from Kashmir. It's very simple. So these things, for example, अभी हम basically ये छोटी छोटी चीजें भी usually हम miss कर देते हैं. But then what happens is, when there is an import or an export taking place in our country, when we are dealing with companies जो import export में हैं, geographical indications are a mandatory thing. So if let's say my company is sending some apples to Arab countries, so I'll have to put that geographical indication saying that this comes originally from Kashmir, and they will verify it. That's how geographical indication works. So geographical indication within our country is not of that use or not of that popularity, because we just ignore those things. But when we talk about import and export, we have that tendency, जहाँ पे we have to prove, we have to give supporting documents saying कि ये कश्मीर के apple हैं, and these are the documents that come with it, and this has a GI attached to it, and there is a GI number. जो GI number is valid for 10 years. So that 10 years, जैसे हम patent बोलते हैं 20 years, GI is usually valid for 10 years. So that goes with it. So this is another complexity in our country, saying that IPR के लिए, first of all, we don't have a standardized law. We don't have a uniform law. Because since we are into a habit of bringing so many legislations, so many acts, so many rules, regulations, that we tend to forget that we don't have a uniform body governing it, right? Which causes more and more confusion. And if let's say there is a geographical indication product, then you have to go to that particular office, then you have to face all those major steps that they give, and only then you can get that registered, correct? But then looking into, like, till now we have discussed all the negative aspects, like the challenges or the difficulties that we have in our country. But there are certain opportunities, or there are a major gap where we as lawyers can definitely fill it in, right? It's not necessary that you have to be an advocate for that. It's not necessary that you have to be an academician for that. It's just that if you have that interest and that knowledge, that opportunity can definitely be taken. I'll give you an example for that as well. Let's say we would have heard so many online companies that are acting right now. For example, Flipkart, Big Basket, Amazon. And if you look at, just have a curiosity, ठीक है, after this meeting, just check इनकी governing body या फिर इनकी parent body कहाँ पे registered है. ऐसे कंपनीज के सारे जो ओरिजिनल बॉडीज हैं या फिर हेडक्वार्टर्स जिसको बोल सकते हो, दे आर ऑल रजिस्टर्ड इन कर्नाटका, बैंगलोर, ओके, बेंगलुरु. व्हाई? there must be a reason, right? It's not like only Bangalore people are intelligent and they are forming companies daily. It's not like that. It is because कर्नाटका का जो स्टेट लॉज है वो कंपनीज को बहुत प्रोग्रेसिव वे में हेल्प करता है, right? So it gives a benefit of tax where you can save tax. Like, let's say if you're going and opening a company in Karnataka, in the state of Karnataka, you can get a lot of benefits. That's how the major number of companies, like online e-commerce companies, are opening in Karnataka. They might operate throughout India. They will deliver anywhere in India, but then their head office would be in Karnataka. Why? Because Karnataka respects the IPR. They'll give trademark easily. Their protection ways are different. And with the help of the trademark, with the help of everything, you can easily get the infringement rights. The companies can easily fight cases. Jurisdiction will be Karnataka. Jurisdiction will be Bengaluru, where the courts will fight, right? So these type of developments should be uniform throughout. That is one major suggestion that we can always look into, that the states should have a uniform law. All the states, if the states have a uniform law, what will happen is it will lead into more and more companies forming in all the states, not just one state where the companies are getting accumulated and growing day by day. It would be like as if more and more companies are coming into play in all the states equally, right? So these things are noticed only when there is a case, or only when there is a problem relating to it. So these are the aspects where only people with a knowledge of law, because why I say people with a knowledge of law, because it's not like particularly we are studying one subject. We are studying all the subjects, right? We are studying all the aspects of IPR. We are checking that all the aspects of IPR are covered in comparison with the international laws, because IPR is majorly an international law. So we are governing everything and then moving into place. And when these things will start coming, like let's say more and more litigation cases are put, more and more pressure is put, definitely there would be a change that we can see coming in. Correct? Government will also take measures. Right now, the intent of the public is also not very in favor of IPR, and hence the government has taken only restricted measures in it. Right? As and when you like, that's why I put the example of globalization, because when globalization happened in 1991, new economic policy came, people started to put that pressure. Why? Because more and more companies from abroad were coming with us as a competition. And that was a moment when our Indian companies got afraid. Ki, Arey, if this company comes here, what will happen for my rights? Let's say I am also selling something, this person is also selling something, Competition Act के हिसाब से, what is going to happen? People जिनके पास पैसा है, they'll go with foreign companies. They'll say कि foreign products है, चलो हम वो खरीद लेते हैं. That point will come, that competitiveness feeling, that would come. And that goes hand in hand with intellectual property rights. That Competition Act, इसलिए whenever you study Competition Act also, you can look at the act as if there are many uniformities with intellectual property rights, because it's all interconnected. Those things are interconnected, right? So if taken with an interest, if seen with the international concepts, intellectual property rights has a huge role in our country, and it has a long way to go, because it is one of the field where the researchers have been very less, and that is only because we lack interest. We are worried. हम वो टॉपिक छूने से पहले ही डर जाते हैं, सेइंग कि अरे इसमें क्या होगा, व्हाट इज आवर अंडरस्टैंडिंग, व्हाट इज गोइंग टू हैपन. सो दैट फियर leaves us behind, and that's why we are behind even with so many legislations and everything. So if we look at the aspects of growing companies, if we look at the development that we are right now taking, we are having GDP, so many policies that we have, daily companies are opening in different states, different areas, different rural parts also. Many rural vendors are also coming to e-commerce to sell. Right now, if you look at the situation, there are so many local vendors who are selling their products in e-commerce sites, jo ki pehle it was not possible. It was just a market-based system where somebody from a rural part was going and taking things in a cart and selling. But right now, it's not like that. Even people from rural areas have registrations with e-commerce sites, and that's how. And it has a big background of it. Why? Because we can protect their rights. We have to protect their rights. Otherwise, these things will stop coming into play. Right? The business will stop flowing. So intellectual property right has a huge role. It's just the understanding concept that we are not doing, the research concept that we are not putting into play. If those things are done together with the aid of the government, I strongly believe that intellectual property rights has the strongest field. Because right now, what we are looking for criminal things or the civil cases, we have already set up a huge mechanism. But that mechanism is definitely lacking for intellectual property rights. And that can come only when students like you and people like us take that interest and go ahead. And more researchers can be done, definitely. So that's it from my end. And I would like questions. If anyone has questions, please go on. Any questions? Somebody were having some doubts. You can unmute yourself and ask. Please go on. Sir, hello. Yeah, I can see a hand going up. Can you unmute yourself?
Hello. Am I audible?
Yeah, you are. Please go on.
Yeah, ma'am. Thanks for explaining us this on this topic. I have a question regarding the transferability of the trademarks and copyrights. So
Correct.
basically, when somebody acquires IP, which
Mhm.
may be in the form of trademark or a copyright, what are the necessary steps and processes that one should stick to, while acquiring? For example, if I'm trying to acquire somebody's brand name, and then market into a particular region, right? So I would need to follow certain legal process so that there is all the process regarding this is taken care of. So if you can elaborate a bit on this point, it will help me.
Sure. You just want to know the necessities that we need to look at when we are going for an IPR, if my understanding is correct?
Yes, ma'am. Yes, ma'am. Transferability, which means that somebody has the copyright on the and trademark, right? And he is giving to second person, selling it to second person to follow in certain geographical area or region. For example, somebody who is registered in Bangalore, he has the brand, and he is kind of selling it to another person B who wants to market it out in NCR region. So what are the necessary legal steps and processes that may be needed for this process?
Right. So I'll just guide you on that. Actually, see, like I was saying, that since there are various IPR involved, there are various laws for it, right? For patents, there is a separate legislation. For copyright, there is a separate legislation. For trademark, there is a separate legislation, right? So the legislative aspect points of the transferability can be dealt from the Act. But when we talk about the practical aspect of it, there is one major point that we miss out. Usually when a transfer happens, let's say you have put a very valid point. When there is a transferability, there are things that can happen, right? What the things are is, the first major thing that we have to look into is the documentation part. So for everything, what our law or what the governing body always states is, we need to have things written out on paper. And that paper is not just a paper where you can just write and put the conditions. It should be a registered paper, right? There is a registration. The transferability it has to be put with all the clauses in a paper, and that paper has to have the provisions which have been dealt in broad. What I mean by that is, what happens is, nowadays we have a tendency, like let's say you are making an account in some e-commerce site. Do you take time and read all the things that are written in privacy policy and everything? We don't, right? We usually, what we do, we just skip through and we just tick and we just enter. So that's the tendency with people who are even transferring or even registering for that. So the first important thing is the documentation that you need to focus on. Because if the documentation is thorough, let's say there is a trademark number that you are getting transferred to, that with that trademark comes the conditions, and it has to be always checked whether that transferability is full or in partial. Let's say if I have some IPR and I'm transferring it to you, I can even write that I'm transferring only 50% of it, correct? And later on, when you are starting to get profits or when you are starting to go on with things, I may also come to you and ask for profits, saying ki up to you are making profits, you give some profits to me also. That can happen, and that has happened in various cases. So the foremost important thing that you will have to check is the documenting, because only when the documentation is clear, precise, and covers all the provisions together with the mechanism of dealing, or let's say the mechanism of solving, which is the court, like let's say either arbitration hoga, mediation hoga, conciliation hoga, like whatever you want, or a court procedure, those things should be mandatorily mentioned in a document. And that document is the foremost thing for anything, let's say for acquiring or let's say for transferring. I hope this answers your question.
Yes, ma'am. Clear, ma'am. Thank you.
Yeah. Anyone else? Any more doubts?
Students, if you are interested in asking any question, please raise your hand. Okay. Ma'am, I think students. Hello, am I audible?
Yeah, ma'am, you're audible.
Thank you so much, ma'am, for giving us your valuable time. And we are very privileged to have us with you at IMT Group of Colleges, Law College. And I think there are no more questions, so we must end this session.
Sure. Thank you so much for having me here. And if there are any doubts, people can all the time contact me. There's no problem. And I'm always associated, and my company is associated with IIMT. So we'll always be privileged to come and attend a webinar. Thank you so much for the opportunity.
Thank you so much, ma'am.
Yeah.